My name is Wei Yanghong. I'm the managing partner of Apollo Attorneys at Law in Taipei, Taiwan. I'm admitted to practice law in both Taiwan and the New York State. For the past 20 years, my practice experience mainly focused in Taiwan. And Apollo Law is the law firm I established for my own practice. My main practice areas are majorly business-related disputes and compliance matters, including civil law, including civil and criminal procedures, corporate, financial, and securities laws. I also regularly advise my clients concerning labor and regulatory compliance matters in Taiwan. Concerning my practice in area, one thing I want to especially mention is that we're familiar with handling complex cross-border and multi-jurisdictional disputes, especially in corporate fraud and bankruptcy disputes. We have the experience working with many international professionals, including lawyers and accountants. And I personally work with many international law firms. Some of them are big names in the industry like Paul Hastings, Orrick, Akin Gunn, Hogan Lovells, and Quinn Avenue. Because we do cross-border corporate fraud, false financial statements, and bankruptcy cases, which generally involve many complex civil and criminal lawsuits across the world, we have intense experience in coordinating and working with international professionals, and we are also familiar with managing complicated legal projects. This experience has made us very sensitive to potential legal and business risks hidden under the different legal jurisdictions and frameworks. Sometimes clients or even foreign lawyers, they might consider Taiwan legal issues through the understanding of their own jurisdiction, but it is quite usual that such understanding may not be compatible with our legal practice. So this kind of sensitivity helps us to serve our clients and work with foreign lawyers well, and may avoid such kind of unnecessary mistake due to the misunderstanding of Taiwan law and court practices. We have a wide variety of client base, including some of them are large international business group like UMC, Moselle, and WaferWorks. They are for the chip manufacturing business. Others includes TSMC, Bankista, Lite-On, MyTech Group. We are also engaged for a wide variety of business-related type of cases, including infringement of IP and trade secrets, corporate securities fraud, contract dispute, labor dispute, and the relevant corporate and regulatory compliance issues. We are also engaged by our clients to negotiate and review all kinds of commercial contracts and joint venture shareholders agreement, something like that very often. Earlier this year, in late August, just 3 months ago, we have just successfully defended our client in both the civil and criminal proceedings in the Mega Bank insider trading case. This is a very high-profile case happened due to a 1.8 billion US dollar fine imposed by the NYDFS. That's the New York Department of Financial Service in 2016 that shocked the Taiwan press and the society. After the 9 years of lengthy and complex litigation with constantly different motions, applications, and cross-examination, we ultimately achieved a full acquittal judgment for our client, which is now already final and irrevocable. My client is very happy because this case had already troubled him and his family for 9 years. And now finally, there is no any potential lawsuit troubling him anymore. And another case I want to mention as my career highlight is the BenQ Siemens bankruptcy case. In 2005, BenQ acquired a mobile phone manufacturer operation from Siemens, which is a well-known merger and acquisition deal in the mobile phone industry from the worldwide scale that made BenQ Siemens the fourth largest mobile phone manufacturer in the world by then. Unfortunately, due to substantial losses, BenQ Siemens was forced to file for bankruptcy in Germany. And the bankruptcy trustee filed a bankruptcy claim against its shareholder, BenQ Kista. That is my client. And they filed the case in the German court at the claim amount of more than 300 million euro dollar. If BenQ Kista would lose in the German lawsuit, it would go bankrupt too. So it's a dead or alive case for my client. And our client did try to negotiate with the trustee, but without any result, because the trustee thought that he may win. Of course he did, because it is in the German court. So the trustee's settlement offer is totally unacceptable at all for our client. But he still just stick with this, so the negotiation have no progress. So considering the dire situation, we work with our client's law firm in Germany, that is Hogan Lovells, and advise the BenQ Kista to file a counterclaim to declare that the trustee's claim does not exist. Of course, this time we file it in the Taiwan court. Once we successfully persuaded the Taiwan court to accept that Taiwan is a venue inconvenience to trial the bankruptcy case, the trustees attitude turned fully and settled with our client with a very favorable term to our client. As I may remember, because our client, it is a listing company in the Taiwan Stock Exchange. So they had already made a quite substantial reserve for potential loss in the previous years of financial statements. So once the settlement deal is signed and large amount of that reserve was reversed, we're actually accounted for most parts of the client's profit that year. And I mentioned the BenQ Siemens bankruptcy case not only because, of course, the claim amount is high and it is a high-profile case, but because this case may show that we know that important issue for the client is not simply winning or lose in the loss alone, but to properly handle and survive legal risks. Even though we did not ultimately prevail in that bankruptcy case, but by thinking outside of the box, we filed a counterclaim in Taiwan, and we successfully helped the client to achieve the goal it really wants. That is to survive. So to resolve the dead or alive danger in the most swift and cost-efficient way possible. So we are law firm not only focused upon winning or lose alone, we also try to resolve the client's legal threats in a timely and cost-effective way. First of all, of course, I want to thank GLE for recognizing my legal work and career. I joined GLE hoping that your prominent global law network may connect me with more outstanding international professionals, so that we, as a boutique law firm not strong in law firm size, may still provide my clients and also potential clients, either foreign or domestic clients, with a broader and comprehensive international support.